This morning at 10:03 a.m. Eastern Time, the Supreme Court of the United States issued a one-sentence order that closed the final escape route in this case. Application denied. 9 justices, 0 dissents, no explanation, no opinion, just 2 words that ended months of legal maneuvering. And that order arrived exactly 72 hours after Melania Trump's legal team filed a proffer agreement with federal prosecutors. A document that outlines evidence she's prepared to provide in exchange for immunity consideration, 2 earthquakes 72 hours apart. Before you dismiss this as drama, let me be clear. I'm going to show you court filings and proffer agreements, all public record. Here's what just became legally binding. Melania Trump has waived spousal privilege voluntarily. The evidence falls into 3 categories. First, financial documents showing knowledge of fraudulent valuations. She signed joint tax returns for 6 years. A signature on a joint return creates legal exposure for both signers. Second category, communications. Text messages discussing property values and emails with accountants. And recorded phone conversations where valuations were discussed in the context of loan applications. Third category, witness testimony that corroborates what accountants and bankers have already told the grand jury. The Supreme Court's rejection means no more appeals. The grand jury can hear her testimony within days. Monday afternoon, 2:00 p.m. Eastern, her attorney files the proffer agreement. A proffer is a preview of the witness's testimony. Exactly 24 hours later, the defendant's team files an emergency appeal to block her testimony. They knew this was coming. Unanimous rejection. Justice Thomas, Alito, Gorsuch, Kavanaugh, Barrett, all Trump appointees didn't dissent. The landmark case is Trammell versus United States. The decision to testify belongs to the witness, not the defendant. So what happens next? The grand jury meets on Tuesdays and Thursdays. I expect her to appear within the next 7 days. If she provides new evidence of coordinated false statements, prosecutors may seek a superseding indictment. Her proffer mentions a specific phone call from March 2020. That call could be the agreement for a conspiracy charge. The trial is currently scheduled for September 16th. With this appeal denied, that date will hold. This case sets 3 precedents. First, we've never seen a presidential spouse flip like this with joint financial exposure. I've seen spouses flip in mob cases and Enron, but this at the presidential level is entirely new. The third precedent, accountability applies regardless of wealth or status. The system refused to be manipulated. I'm tracking 3 developments: grand jury activity, the defense response, and the final immunity agreement. The system worked today because the court followed precedent. Subscribe to follow this trial to its conclusion. The sealed transcript just leaked. I reveal her exact words about the financial fraud in this video right here. You need to see this.